Good day, everyone, and good day to all my colleagues in Rizal Memorial Colleges. We are here today to present to you a case on public international law, and the case is Vivendi versus Argentina. It was originally filed late 1996, and it was terminated with the second decision on the annulment issued on August 2010. So before we start, let me introduce my group mates. So to present to you the facts of the case, Mr. Salman Johayr will be the one presenting that, and I will be the one presenting the arbitration proceedings. And for the legal issues, Sir Ryan Lagnayo will be the one discussing it. So to give you a brief information, so the applicable treaty in this case is the France-Argentina bilateral investment treaty, and the issues are alleged treaty violations on exploration, fair, fair and equitable treatment, protection and full security, and other legal issues are is jurisdiction. So without uh, further ado, I'd like to call in Mr. Salman to discuss to us the facts of the case.
For the facts of the case, the 1995 concession contract grew out of a 1993 decision by the government of Tucuman to privatize its water and sewage facilities that were being operated by provincial authority. The claimants here allege that almost immediately after they took over the water and sewage services concessions for Tucuman, they were systematically deprived of their rights under the France-Argentina Bilateral Investment Treaty, or the BIP, by the provincial authorities. The claimants asserted that the provincial authorities acted wrongfully when they, first, unilaterally modified tariffs contrary to the concession contract. Second, they used the media to generate local hostility towards them. Third, they made numerous unjustified accusations against the concessionaire while themselves acting in flagrant violation of the agreement. And lastly, they interfered directly with CAA's customers' relationships, including inciting its customers not to pay their bills, forcing the claimants to renegotiate the concession contract. The claimants argued that these alleged attacks destroyed the economic value of the concession contract and left them with no choice but to terminate the concession. Then they were held hostage by the provincial authorities and obliged to provide services for a further 10 months. Now, after they were released from their obligation in October 1998, the harassment continued, culminating in a series of targeted enactments to prevent CAA from collecting outstanding invoices. The claimants initiated the ICSID action on the grounds that these acts and omissions of the provincial authorities were legally attributable to the Argentine Republic. They further argued that the federal government itself directly breached the BIP by failing to properly control and correct the actions of the provincial authorities. Now, according to the claimants, these actions and omissions constituted a violation of the fair and equitable treatment, or the FET, and full protection and security standards in Article 3 and 5, Paragraph 1 of the BIP, and an expropriation of the claimant's investment, contrary to the Article 5, Paragraph 2 of the BIP. The claimants sought damages totaling to 316.9 million US dollars plus compound interest from November 1997 for the harms inflicted upon them. Now, Argentina argued that the case involved exclusively contractual matters and that the actions of the provincial authorities over which the tribunal did not have any jurisdiction. Argentina asserted that CAA doubled the water bills to an impoverished population without warning and without noticeably improving service. Furthermore, the CAA destroyed the confidence of the population by negligently delivering black, undrinkable, and potentially unhealthy water over a period of many weeks. Argentina asserted that BIPs were never intended to protect investors from the consequences of their own mistakes, nor to provide them with an insurance policy against the due exercise of the state's regulatory activity, and that this is even more so is the case when the service provided is as vital as the provision of water and sewage services. Argentina then claimed that far from constituting an expropriation or unfair and inequitable treatment, the province of Tucuman's conduct merely discharged the province's responsibilities both as a contracting party and as a government, and therefore the claimant's case should be dismissed. Now to discuss to you about the arbitration proceedings, may we have Mr. Ampatuan.
Thank you, sir. Thank you, Mr. Salman. Now, in the arbitration proceeding, uh, it it actually started in November 21, year 2000, and in the original proceeding, it addressed Argentina's jurisdictional objection and the merits of the dispute. Now, the tribunal determined that it had jurisdiction over the dispute, and in reaching such conclusion, it rejected Argentina's argument that the forum selection clause in a concession contract, which required the contracting parties to submit all disputes regarding the contract to the exclusive jurisdiction of the Tucuman's local administrative tribunal and prevented it from hearing the case. Nevertheless, the tribunal dismissed the claims of the claimants on the grounds that the claimants had to pursue their rights in the in those local courts before seeking relief under the bilateral investment treaty. With respect to the remaining claims whose resolution did not depend on the interpretation and application of the concession contract, the tribunal dismissed them on the merits, stating that the evidence failed to establish that Argentina had breached the bilateral investment treaty either through its own action or omission, or through the action or omission of the provincial authorities attributable to the national government. Now, pursuant to Article 52 of the Convention, claimants applied for annulment during the first annulment proceeding, and the annulment committee annulled the awards in part and agreed with the tribunal's determination that it had jurisdiction over the dispute. It determined that the tribunal had exceeded its power by failing to examine the merits and the claims regarding the action of the Tucuman authorities, and that the annulment was therefore warranted under Article 52, Paragraph 1 of uh, the Convention. Now, the claimants resubmitted the dispute in the Convention, and in the resubmitted proceeding, the tribunal determined that Argentina Argentina had breached the BIT's provision on fair and equitable treatment, protection, and full security and exploration. The tribunal awarded damages amounting to $105 million plus 6% compound interest, and it further determined that each party should be liable for its own costs with respect to the substantive proceeding on the merits, but Argentina should be liable for all the costs regarding jurisdictional phase because its objection to the jurisdiction had already been raised and found meritless. Argentina applied to annul the award on various grounds, including the fact that the tribunal wrongly accepted the jurisdiction and failed to apply the applicable law, which consisted of the provincial and national law and the terms of the concession contract. Now, Argentina further argued that the annulment was warranted because the tribunal improperly replied on some evidence and information, including allegation relating to the government's purported campaign to destroy the concession contract while ignoring other important evidence and information, including consideration relating to the rights of to water as human right. Now, Argentina argued, which was supported under the subsection B, D, and E of the Convention's Article 52, Paragraph 1, which relatively permits annulment if tribunal manifestly exceeds its power seriously departs from a fundamental rule of procedure or fails to state reasons upon which the award is based. The tribunal's decision of not granting the annulment of the Vivendi 2 award provides that there are no findings or aspects therein that met the high standards which warrants the annulment on this case. Now, to present to you the legal issues of the case, may I call in Mr. Lagnayo? May I call in Sir Ryan?
Thank you very much, Mr. Ampatuan and Mr. Salman. With regards to the legal issues, in this part of the discussion, I'm going to present how the tribunal addressed the legal issues that are relevant to the case. In the expropriation, in holding Argentina liable for violating the BIT's prohibition on unlawful expropriation, the tribunal held that there was extensive authority for the proposition that the state intent or its substantive motives are at most a secondary consideration when determining whether a measure is expropriatory. Although improper motives could weigh in favor of showing a measure to be expropriatory, this was not a requirement to establish an expropriation. It's because the effect of the measure on the investor, not the state intent, was the critical factor. Turning to the present case, the tribunal noted that the structure of Article 5, paragraph 2 of the BIT directed it first to consider whether challenge measures were expropriatory and only then to ask whether they complied with the conditions listed in the treaty as being necessary to render the expropriation lawful, example of which is that the expropriation be done for a public purpose, be non-discriminatory, not be contrary to the specific commitments, and be accompanied by payment of compensation. The tribunal held that if it concluded that the challenge measures were expropriatory, there would be a violation of Article 5, Paragraph 2 of the BIT, even if the measures might be for a public purpose and non-discriminatory, because no compensation had been paid. The tribunal's interpretation of the expropriation standard is significant because it stands in apparent contrast to the view of some other tribunals that non-discriminatory regulations enacted for a public purpose are not compensable expropriation or are not compensable expropriations unless specific commitments to refrain from enacting the challenged regulations had been given. In the fair and equitable treatment in defending against the FET claim, Argentina argued that the requirement in Article 3 for host states to grant foreign investors fair and equitable treatment according to the principles of international law required states to accord with the minimum international law standard of treatment. Argentina further asserted that this standard, as classically formulated in the 1926 NER decisions, is violated only when the government's conducted amounts to an outrage to bad faith, to willful neglect of duty, or to an insufficiency of governmental action, so far short of international standards that every reasonable and impartial man would readily recognize the insufficiency. The The tribunal rejected Argentina's argument that the FET standard was so limited, even going so far as to the label near standards as obsolete. The tribunal additionally declared that there was no doubt that the fair and equitable standard includes a government's obligation not to to disparage and undercut a properly granted concession. With it standing one granted by a predecessor government in order to rescind the compensation or to force a renegotiation applying to do harm standard, the tribunal determined Argentina had directly undermined the claimants' legitimate expectations of their investment and violation Article 3 of the BIT. The Vivendi second tribunal's interpretation of the FET standard is notable for its breadth. Its rejection of the narrow new formulation as obsolete is also notable given that as recently as the 2009 Glamis decision under NAFTA, that exact formulation has been described as representing the FET standard under customary international law. It should be recognized, however, that the Vivendi second tribunal's adoption of a strong interpretation of the FET standard did not appear to matter the outcome of the case. The tribunal stated that even if it had applied the narrower standard advanced by Argentina, it still would have found Argentina to have breached the FET obligation. In the jurisdiction, Argentina had objected that the tribunal did not have jurisdiction over the dispute because the dispute arose from the concession and contract, and the parties to that agreement had contrarily committed to resolve all disputes before the administrative tribunals of Tomokuman. The tribunal rejected the argument. In doing so, it relied on Article 8 of the BIT, which grants investors the right to submit disputes relating to investments to ICSID. According to the tribunal, the contractual forum selection clause did not and could not constitute a waiver by the claimants of their rights under Article 8 of the BIT. So to file the pending claims against the Argentine Republic.
Okay, thank you for that, Sir Ryan. And that's it for our case discussion. I hope that you learned something from this presentation. And I would like to thank also my group mates, Sir Johayr Salman and Sir Lagnayo Ryan. And that's it. And thank you and goodbye.